We commit today's activity into your care, and we ask that you will grant us wisdom, knowledge, and understanding. Grant the speaker wisdom to speak and to lecture us on the topic, that at the end, Father, we will learn a lot to guide us in our profession. We commit all those connecting online into your care. We ask that you will open our minds so that at the end of the day, we'll benefit from today's lecture. We thank you and we bless you in Jesus' name. Amen. Let's please take our seats. We want to invite our brother Kingsley, Xavier Kingsley, to introduce the chairperson for today's occasion. Thank you.
Good afternoon. Unfortunately, we don't have any lady among us here, except on the virtual platform. My name is Kingsley Boatin. I'm greatly honored to be called upon to introduce the chairman of this occasion. I must say that I don't want to bore you with all the credentials of the chairman, but I've known this person over 30 years. He's been my SP, he's been my everything, he's been my mentor. I look up to him for a lot of things, and so I don't want to bore you. He's one of us, and he's the president of the years, and he has an immense knowledge about our profession. He's no other person than our own Dr. Surveyor, Engineer John Amaglu. Mr. Chairman, your audience, your chairman. Thank you.
Thank you very much, Xavier Kingsley. That's a fast one. I think I will ask Xavier, Dr. Joseph Amaglu, to take you to Nigeria so that you can try to go the Nigeria way for us sometimes. Chairman, we want you to give us your opening remark as we kickstart the program for the day.
Good afternoon, ladies and gentlemen. We don't have ladies in here, but I know that we have a lot of ladies online. Yeah, thank you very much for giving me the opportunity again today to chair this important function. And I just love the way I was introduced. Very brief and very fast. And I also do the same. Today is a day that we've all been looking for. And we have somebody who is going to do justice to our team. I had an opportunity of meeting him in person when we met at Soga Coffee, when we were looking at 7C7. So I know him very well. And I know that we are in safe hands. So without wasting much time, let's all get set and then let the ball start rolling. Thank you.
Thank you, Chairman. The way things are moving fast and short, I believe we are all eager to listen to the speaker. And so without wasting much time, I want to invite the planning committee chair to introduce the speaker for today.
Thank you, MC. It looks like a trend has been started and it must follow same. The speaker for today on our topic, as is behind me, Land Act 2020 at 1036 and the Land Surveyor. With this topic, we need somebody who has an in-depth in law and has in-depth in land administration. And for that matter, we look around and we find a gentleman who is a lawyer, and for that matter, a very high experienced lawyer, a lecturer at the school, board on many organizations in the country, has his own firm, and a law firm. Then he is also a chairman of Iceberg Group of Companies and a whole of companies which he sits on as their legal expert. This is the man I'm talking about. Lawyer Kwame Jan is our man for the day, and let's welcome him.
Should I take this? I'm happy to be here, particularly because it's the land surveyors and the license surveyors. I had a previous encounter with some of you when we were working on Act 767, and I must say that whatever went wrong at that time, let's get over it and move on. All of us meant well, and fortunately or unfortunately, even though some of the things we tried to do have not been done in the manner we all expected, at least we made some progress. I am here to talk about Act 1036, the Land Act 2020, Act 1036, and how it affects the land surveyor. Let us talk about the regime before Act 1036 briefly. Before Act 1036, generally for the land sector, we had the Administration of Lands Act. But let's even start from the earlier one. We had the Land Registry Act of 1962, Act 122. We had the Administration of Lands Act 1962, Act 123. We had the Concessions Act, also 1962, Act 124. We had the State Lands Act, also 1962, Act 125. We had the Minerals Act, also 1962, Act 126. And particularly for the kind of topic we are involved in today, for the surveyor, we had the Survey Act, also 1962, Act 127. So primarily, this is what was the legal architecture by 1962. Now, over time, based on our circumstances, new legislation were introduced. So, for example, when you go to the point where the Republic wanted to implement titling, the Land Title Registration Act, PNDC Law 152 was enacted, and it became a part of the regime. Now, so we had this setup for the land sector. Then come the Land Administration Project, and Mr. Akwa and co were around. And I happened to be the legal specialist managing the legal reforms portfolio of the lab. So we started a process of looking at all the issues relating to the legal and institutional framework for the land sector. We got a series of consultants to look at these things, and we had extensive stakeholder consultations also to try to understand the problems of the land sector. We had at the backdrop the land policy document as well, which had also tried to catalog some of the issues confronting the land sector generally. So with all of these, we started the process of looking again at the legal and institutional reforms for the land sector. So what did we achieve? At a certain point, we were going to prepare what we called the Omnibus Land Act, the big act, which will deal with both the substantive law and the institutional framework. In planning, the law on spatial planning. So we were looking at one piece of legislation which will deal with the institutional arrangements for the land sector, the institutional arrangements for the planning sector, then the substantive law for land and planning as well. Now, what we realized at a certain point was that this piece of legislation was going to be too big and too complicated. So we were advised, and the advice was well taken, that we should split the legislations into different modules for different thematic areas. So the first part, which was spinned off, was the law on planning. So another set of consultants were engaged to prepare a draft bill on planning, which has been passed as the Land Use and Spatial Planning Act of 2016, Act 925. That is operational. So planning and its issues and regulation and institutional framework was decoupled from land properly so-called. So we had the planning regime separated from the land sector. Then it was decided that we should pass a different legislation to deal with the institutional framework for the land sector. Once we decoupled land and planning, it was decided that we should pass the institutional bill separate from the substantive bill, which will deal with land. That's how come Act 767 of 2008 was passed. So Act 767, Land Commission Act 2008, Act 767 was passed. Now, as many of us still remember, what did Act 767 do? 767 simply took the agencies which were existing as independent land sector agencies and merged them under one Lands Commission as provided in Article 258 of the Constitution. So we had to bring on board Survey Department at that time. We had to bring on board the Land Registry, the Land Title Registry, and the Lands Commission as it was at the time. We had issues with Administrator of Two Lands because of constitutional amendment and the delays associated with constitutional amendments. Because the Administrator of Two Lands is created by the Constitution. And at that time, the exigencies were such that you could not amend the Constitution. So as a way of getting around a constitutional amendment, we kept the Administrator of Two Lands outside of the reform agenda and left the OASL as it was under the Constitution. So as you all remember, these previously disparate agencies were made functional divisions of a new Lands Commission, which was created by all of us at that point. And if you remember, that was the source of the discontent, for which I have already apologized for the entrenchings some of us had taken at that time. And the apology is sincere, sincere. So we got 767 passed. And then we needed to pass 1036. And that also came up because we had very extensive consultations across the country, to be honest. Act 1036 is one of the most extensively consulted around legislation in this country. Because for those of you who still remember, when the drafts were done, and I'll tell you a bit about the drafts. 1036, the first draft of the memorandum and the first draft of the bill were done by me alone. I sat alone and did the first cut for my committee members to look at. Now, what were the materials for the first cut? In the course of the stakeholder consultations, we had video and audio recording equipment. So we did 3 consultations for all the judges and magistrates in this country in 3 zones. One for the South, one for the Middle Belt, and one for the North. So we met all the judges when we crafted the drafting proposals. And then we met the National House of Chiefs and all the regional House of Chiefs. And then we held zonal consultations per region. All the district assemblies were invited to the regional headquarters. So all the proceedings were recorded. We had a team that were doing transcription. So they would transcribe all the public comments and input. And then when we go back to base, we take all the comments that were made and try to find legislative language to take on board what should be taken on board. So if you followed the interactions about the bill when it was passed, generally, it has received widespread acceptance in this country. For the very couple of weeks after the bill was published and printed by Assembly Press, there were no copies available. Ghanaians walk to Assembly Press and buy out the copies. And that's the extent to which this bill law has reached to the people. And you would also notice that the language is not too convoluted. You don't need to be a lawyer before you will be able to follow most of the provisions. Yeah, there are a couple of difficult provisions, but you don't need to be a lawyer to follow most of the provisions of Act 1036. So, in a nutshell, this is how we got Act 1036. It was passed by Parliament in July and received the presidential assent in December of 2020. So it is the law now. Now, before I come to the specifics that this bill has brought to the survey profession, let us take some of the innovations that this bill has brought. Generally, the first and probably the most important change that Act 1036 has brought to the land sector is that for the first time, we have a clearly set out regime of the recognized interest in land in this country. We have a very clearly set out regime of land interests recognized in this country, clearly set out, without language which will create more confusion. Now, many years back, under the old system, we were told that the regime of land interests and in school, land economy, and so on, in land law, we were told, and as Olenu and Co. wrote, that you have the allodial title, you have the usufruct or the freehold, and you have customary tenancies. Now, this act says in section 1 that the interests in land that are recognized in Ghana are the allodial title, the common law freehold, the customary law freehold, usufructuary interest, leasehold interest, and customary tenancy. So these are the interests in land that are recognized under our law. So the allodial title still sits at the apex as the highest interest that one can claim in land in this country. But you remember previously, we said After the allodial interest was the usufruct or the freehold. And the freehold was either subordinate interest, subordinate title, and so it pretty confusing, the system that we had. And the freehold was also the same as the usufruct. Now, the reason I was saying we have clarity is that now you take the allodial title, you take the common law freehold. It is that interest in land whose incidents are determined by the English common law. Now, if you go back to chapter 4 of our Constitution of 92, Article 11, which sets out the sources of law in Ghana. The common law of England is part of our law. See, because of the reception. What colonial rule did was the British came here with their law, the judge-made law, which was called the common law. And the Supreme Court of Judicature Acts of 1886 pegged that as the date of reception. So the English common law, which was in existence as of that date, became part of our law. And our constitutions over and over have carried out or carried on that principle that the common law of England, which was in place as of the date of the reception, is still part of our law. That's the judge-made law. So when you talk about common law freehold, what you are saying is that it is that interest in land which has the characteristics as set out in English common law. Then you have the customary law freehold, which is that interest in land whose characteristics are determined by the customary law. And the same chapter 4, Article 11, says that the customary law of Ghana are the practices of particular communities in this country. So, common law freehold, customary law freehold, and then now we have the usufruct, which is that interest in land which a subject of a stew or a member of a family would acquire when that person exercises their inherent right to a vacant portion of the community's land. So many years back, when we go to our villages, their family house, if you ask who gave them the land, they might tell you they don't remember. And the reason was the subject of the stew or members of the family had a customary entitlement to settle on any portion of the land which was not already encumbered. And if you remember your land law, there's a case called Nokwe Tete and Mam, in which the court said, where there are economic trees on land, it is a prima facie evidence that that land is not vacant. That it means that a subject of the land owning stew has applied industry to develop the land. So your entitlement as a subject or a member of the land owning group is not to land which has already been cultivated by another member, but your entitlement is to free vacant land. And when you go on it previously, you didn't even have to ask for permission. And there is a case which illustrates. There's a case of Obli and Ama, which says the subject need not ask. Once there is vacant land and you move on, you take it and it's deemed to have been taken. But then there was another case, Amate and Hammond, which said, no, now because the land has to be regulated, the subject has to go to the managers of the land, whether the stool, the clan, or family, and apply properly to get a part of the community's land. And then the leasehold interest, there's a case called Nana Bedi Akwatre and Osewusu, in which our Supreme Court said leases are alien to our customary law. In other words, leases were brought to us by the colonial guys. Many years back, if you needed land, the people who will not lease the land to you, they will show you a place. And it's said about Gans that they were too generous, that they can even throw a stone and say that where the stone lands, that's the outer limit of the land they have given you. Because there was this customary perception that you need strangers to build the community. So allow everybody in, and so on and so forth. So leases with land given to you for a fixed term, when it comes to an end, you have to leave the land and go. It's not part of our customary law. But today, we are put in this legislation that leases are recognized as part of the interest in land. And the last one is customary tenancies. All these sharecropping systems, Abusan, Ebunu, and different variants of Ebusan and Ebunu in different parts of this country of ours. Now, when I mentioned the usufruct, I said generally that's the land interest which a subject of a stool or a member of a clan or land-owning family acquires by exercise of their inherent rights. Now, Section 5 of Act 1036, Section 5 of Act 1036 has introduced another dimension. So if you take Section 5, there are two forms of the usufruct. So if you are a surveyor and you go to the ground and you are working, you have to understand that there are two forms of the usufruct. One usufruct is where the subject, somebody who is related to the land-owning group, exercises inherent right. The other usufruct, which is in Section 5.2, is where a stranger has been in occupation after a grant. So the stranger goes in with permission, not adverse possession. The stranger goes on land with permission, and the stranger has been in undisturbed, continuous possession for at least 50 years. That stranger also acquires a usufruct. That stranger also acquires a usufruct. Now, you will notice something. The first four interests in land, they have one and two things in common. The allodial title, the common law freehold, the customary law freehold, and the usufruct. They are all of indefinite duration, and therefore they are potentially perpetual. These four interests, they are all of indefinite duration, and they are potentially perpetual. So they would run and run so far as they are successors. And so far as the grantee, the holder of the right, has not done anything to kind of disclaim or deny the title of the land-owning group. So these kinds of titles are heritable. You can inherit from one generation to the other generation and to the other generation. But you will realize that leases and these customary tenancies may have specific durations. But the first four sets of interests, they can run and run and run. Certain events could terminate or truncate them, but they can run and run and run. For example, when there is the exercise of the state's power of eminent domain, the exercise of the power of compulsory acquisition, these titles will be extinguished. Because when the instrument of acquisition is passed and the notices are published, the acquisition becomes effective, the rights in land prior to the acquisition are extinguished. So there are things which could happen to bring these interests to an end. But otherwise, they will run indefinitely because they are, like I said, of indefinite duration, and therefore they are and like I said, they are of indefinite duration, and therefore potentially perpetual. Potentially perpetual. Now, the next change that has been introduced by 1036, which is worthy of note, is in section 9 of 1036, section 9. Now, this change is the extension of what we call the trusteeship concept from stool lands to other lands as well. The extension of the trusteeship concept from stool land to other lands. Now, to appreciate this point in section 9 of Act 1036, let's go to Article 267, Clause 1 of the 1992 Constitution. Now, 2671 says stool lands are to be held by their respective stools in trust for the subjects of those stools in accordance with customary law and usage. Stool lands. Now, if you go to section 9, that trust has been extended to clan lands, to family lands as well. So it is not just stool lands which are to be held in trust, but family lands and clan lands and Tindana lands are also to be held in trust for their members. In the past, it was only stool lands which were to be held in trust. Now it has changed. So if you look at 9, it says, a stool or skin or clan or family land shall vest in the appropriate stool or skin or clan or family on behalf of and in trust for the subjects. If you go to Article 267 of the Constitution, the reference was only to stool lands. Now, there was a reason for this, because you needed to bring the controls on stool lands to family and clan lands as well. And we will get to that angle soon. Now, for those of you who are around the Lands Commission system, you remember a case called the Republic versus Regional Lands Officer Ho, S. Party Kuluje. This was the case which came out of an application by Professor Kuluje, may he so rest in peace. He got some land in the Hoho area. He applied to the Lands Commission to have a freehold registered for him. And the Lands Commission refused to register the land on the grounds that Article 267, Clause 5 of the Constitution prohibits the grant of freehold in stool land. So they will not register for him. He went to court. At that time, Justice Kingsley Akwa was a Court of Appeal judge who had been taken to Ho to sit as an additional High Court judge. And his position was that the restrictions on the creation of freeholds in stool lands does not extend to family lands. Now, under 1036, the restrictions have been extended to clan and family lands. So the prohibition on the creation of freeholds has also been extended to family and clan lands. But subsection 3 of section 9 says these restrictions will not apply to persons who are subjects of the stool or members of the land-owning group. In other words, the inherent right of the subject to free use of the land has been preserved. So we will not have S. Particuluje again. And this is because when we were doing these drafts, we knew about S. Particuluje and what it meant for some people. Because you know what has happened is, you go to your village. My village is somewhere in the eastern region, Achima Krufufu. I have a small parcel of land. Because I couldn't register a freehold, because of the same restriction, I, a native, would have to take a lease. But the customary law says that we have inherent rights. And this inherent right was to a freehold in a portion of the land. So most of us have become tenants where otherwise we would have been freeholders. Now, so for at least for where we come from, we will not be tenants, but we will be freeholders at least. And this is coming from Act 1036. There has also been some expansion or extension in the law relating to restriction on land holding by foreigners. Now, if you go back to the Constitution, Article 266, from clause 1 through 4, talks about all the restrictions that are imposed on non-citizens. So they cannot hold a freehold interest, howsoever described. They cannot hold a leasehold for more than 50 years at one time, and so on and so forth. These restrictions have been reproduced in Section 10, but prior to the drafts, we had some discussions around the country, and it came out that you needed to determine who a foreigner was. If it is a foreign person, you don't have issues because you can find out a Ghanaian and a non-Ghanaian. But the challenge was with the corporate foreign persons. So the question was, how do you determine a company which is a Ghanaian company or not? A Nigerian comes to incorporate a limited liability company here. Then the next day he applies for a freehold. And the basic law is that the nationality of a body corporate is the nationality of the country in which it has been incorporated. So if you take the law simply on the face value, that Nigerian who has come to incorporate a company here, which has a limited status in this country, has created a Ghanaian company, which can take the benefit that I can take in terms of access to land. So establish a benchmark to determine when company is not a Ghanaian. And remember, there was a case called Balkan Energy against the Attorney General. It went all the way to the Supreme Court about foreign companies. Remember all these water bills and so on. So if you go to Section 10, subsection 10 of the Act, so Section 1010 of Act 1036, provision has been made that for the purpose of this section, a company or body corporate is not a citizen if more than 40% of the equity shareholding is held by non-citizens. So if there is a company and more than 40% of the equity holding in that company is held by non-Ghanaians, that company is not a Ghanaian for purposes of land access. So that company will be treated, even though it has been incorporated here, that company will be treated as a foreigner. It cannot get more than 50 years at one time. And this is fresh. This is not part of existing law. This came out of the consultations. You should also note 11, one of the changes which was brought. But Section 11 is not really an innovation, but at least it's important because it has found its way in a Land Act. It is actually a paraphrasing of Article 17 of the Constitution, which prohibits discrimination. Article 17 prohibits discrimination on the basis of gender, creed, religion, political affiliation, or so and so and so. What Section 11 has done is to say that if you are discriminating against anybody, and here our main target was gender discrimination, because in our rounds, when we were looking at this law, we found out that in some parts of the country, women were not allowed to hold land in their own right. We found out that for some areas, women were required to come with a man. It doesn't matter the age. I asked, how old should the male person be? He said, oh, a male, even if he's 2 years, he's a male. And I said, this is not fair. So Section 11 has taken care of that situation. Now, another innovation which has found itself in the statute, you all know about, particularly those of you who are around the Lands Commission setup, the customary land secretariats. Finally, these have been institutionalized. The customary land secretariats, which all the land owning entities, the groups would have to have, now has legal legislative backing. So if you look at Section 13 all the way to Section 18, deals with customary land secretariats. So all the traditional landowners must have their own customary land secretariats, and their funding and so on are all set out clearly in Section 19. Sorry, Section 13 to 18. Section 13 to 18. You should also note Section 21 and Section 22. Section 21 and Section 22. Particularly Section 22. Section 22 is coming from Section 12 of the Administration of Lands Act, which has been repealed in Section 282. Section 282 of Act 1036 has repealed certain legislation, and one of them is the Administration of Lands Act. Under Section 12 of the Administration of Lands Act, restrictions were put in place about the acreages of stool lands that could be allocated for particular activities, the extent of stool lands which could be allocated for particular activities, like for poultry farming, cereal cultivation, cash crop cultivation, for ranching, and so on and so forth. Now, Section 22 has extended these restrictions to all land. So it's not only stool land, and that's important. Clan and family lands have also been added. So under Section 12 of the Administration of Lands Act, only stool lands were the target. So there were restrictions on how much of stool land could be allocated for particular activities. And you remember how we had issues with all this land grabbing, especially when we were experiencing the oil boom in the Western Corridor. Somebody will go and take 20,000 acres, 10,000 acres, and trying to make a lot of people landless. And only stool lands could be protected. Now, under Section 22, family and clan lands have been added. So the restrictions on stool lands in terms of extent and duration have been extended to family and clan lands as well. And I think this is something that would have to be noted. Now, what else is important for you is Section 33. Section 33 is one area where the lawyers who were involved in this drafting were very selfish. Section 33 says, a conveyance shall only be prepared by a legal practitioner in terms of the Legal Profession Act 1960, Act 32. So I beg you, licensed surveyors, don't draw up conveyances. That's not part of your work. You do the plans and bring them with the schedules. And then my class, we will prepare the conveyances. You will get your share of the money. We too get our share of the money. But that's what, because I've had encounters where some conveyances were prepared by surveyors. It's true, isn't it? You may have encountered some of your colleagues who are preparing conveyances. And they will take a copy of so there is one conveyance which has been prepared. What they do is they change the names and the acreages, and then life is going on. And then they will take it to the area around Mr. Akwa's office, near Elwak. Mr. Akwa, are you still there? Yes, there are the tree unders. You see some lawyers under the trees who are signing off, stamping the conveyances, and life goes on. So, but at least Section 33 says only the lawyers will be in business when it comes to drafting of conveyances. Now, there's something else which I want to draw your attention to. The whole idea of electronic conveyancing. It was one of the issues that came up. Some of us were proposing that we should take this opportunity to introduce electronic conveyancing. One of the challenges was, do we have the institutional and the technical platforms to be able to do it? But some of us also said, make provision for it. We may not have the platform, but make provision for it. So this act has made provision for the use of electronic conveyancing. We had gone to the UK in the course of doing these drafts. We paid a visit to Her Majesty's Land Registry, and the things we saw were mind-boggling. And then we started saying, the interesting thing about that trip was that some of our people had their classmates. Some of our people were trained in the same areas that these guys had been trained. And in fact, most of our people were more knowledgeable than the people who were in HM's land registry. And at that time, a lawyer could sit in the comfort of their office and file a search at the registry of Her Majesty's Land Registry and get his results. Then he's billed according to the number of searches and so on. They had a billing system. So what we thought was, let's try to put together some language in the act which makes it possible for us to be able to do electronic conveyancing if we can create the infrastructure. So that is one of the changes that has been introduced in Act 1036. You should also look at Section 50. Section 50, if you are in Section 50, go to 22. Start with 20. Start with 20. If you are in 22 or you are in 20, you will find some very interesting things there. There is now power given to a holder of the usufruct to be subjected to compulsory acquisition by the holder of the allodial title. Now, what does it mean? What it means is that under Section 50, subsection 20, the land ownings too, if land is required in the community's interest, the land owners too can exercise powers which look like the state's power of compulsory acquisition. In the past, the judicial authorities were such that if the community needed land to expand the settlement and someone had a farm and the person said, I will not change the use, it is my farm, the community couldn't do anything about it. And there are cases which have come to the Supreme Court, including Pastor Yabuate and so on, in which Justice Brobe said the community cannot take the land, even if it is required for the development of the community. Now, in section 50, subsection 20, provision has been made for the community to negotiate and take the land, give that person alternative land or monetary compensation. But what we have done is to say that going forward, the individual interest of a community member should not stand in the way of community progress. What is left is how this will be operationalized. But at least provision has been made for the takeover of land subject to the payment of compensation. You should also look at start from 9, 59 and 10 and 11, 12, 13, 14, 15, 16, 17, and 18. So section 50, subsection 9 to 18. Section 50, subsection 9 to 18. Now, the combined effect of these sections are interesting. You know that when a lease expires by a fruition of time, whatever has been added to land permanently becomes a landlord's fixture, and therefore the tenant has to leave. So if you take bare land and you erect a house on it, and the lease is for 50 years, and at the end of the 50 years, your landlord says they will not renew, you take your bags and you go home. Across the country, wherever we went during the stakeholder consultations, concerns were raised that can the legal system deal with these things when most of these leases come to an end? So provision has been made that if you are an indigent and you have a lease and it expires, it is presumed to have been automatically renewed for the same term. So the combined effect of section 50 from 9 going is to provide for automatic renewals of leases, whether it is bare land given to a subject or bare land given to a stranger. So the landlord will not be able to say, I will not renew. So at least it protects the lessees of land who may be thrown out. And what will happen is most of the time the lessees may not be alive. And that was the worry which was expressed across the country. So people were saying, okay, so what will happen to my children's children? They say they'll be thrown out if the lessor's children say they will not renew. And then everybody was saying, no, then you should do something about it. Then you should do something about it. You know, a particular person had got some land at Deftraco. I think he has made some massive improvements on the property that he acquired. He was asking, so you mean when I'm dead, my children will not have the place? I said, you are dead. Why are you worried about your children if you are dead? But it was real. You know, these sentiments were real, and we had to do something about these sentiments. Now, another thing that you should note about this new act has to do with registration. 3 modes of registration have been introduced. 2 we already know: title and deeds. And the 3rd one is recording of customary transactions. Recording of customary transactions. So the customary land secretariats are required to record all the transactions that they do within the jurisdiction of the customary land secretariat. So we still have registration of instruments or deeds. We still have registration of title, but we have added recording of instruments. Recording of instruments. That's not the end. If you go back to the act, under compulsory acquisition, and you should go to chapter number 7 for compulsory acquisition. chapter number 8 for vesting of land, and chapter number 9 for temporary occupation of land. These are important. So when you go to chapter 7, some key changes have been introduced. One is in section 236. 236. This is titled Unlawful Occupation or Sale of Public Land. Now, you realize that most of the time, government lands are encroached upon, and it becomes a problem for everybody. So, if you look at section 236, 1 and 2, very important provisions have been placed there. And these provisions are a codification of a judgment of the Supreme Court in a case called Memuna Amudi and Entry. Memuna Amudi and Entry. That has been codified. The judgment was a judgment delivered by Justice Datiba, and that has been codified in section 236, 1 and 2. What section 236, 1 and 2 is saying is simple. That notwithstanding anything in the Limitations Act, you cannot claim adverse possession against the state. So, you remember the Limitations Act provision which says, if someone comes on your land, adverse, you have not placed him there, and he remains undisturbed for 12 years, your title is extinguished. And the Limitation Act itself says it should be applied to the state as if it were an ordinary individual. And the state was having issues because the state will take land, doesn't have the money now to develop. The state will put up a human face. Our own people will go on the land and try to do some squatting on the land. When the state comes back after 20 years, they say adverse possession. So in section 236, 1 and 2, clearly stated no adverse possession against the state. It means that if you go on state land for 1,000,000 years, when the state is ready, the state can dislodge you and take the land back. So as surveyors, we should have it at the back of our minds. If somebody comes to tell you to go and survey state land without proper authority and you go and do it, the sanctions attached, you'll be surprised. Because one of the most robust things about this legislation is the sanction regime. In section 12, in 27, in 277, massive sanctions for infractions. So please, no adverse possession against the state. Another introduction, very important change which has been introduced, has to do with article section 238. No cash, no acquisition. The Republic of Ghana would have to show evidence of cash before acquisitions. So the old system whereby the state did take the land without money to pay for the compensation will no longer be tenable under Act 1036. If the state wants land for a project, the state has to raise the cash, drop the cash in an escrow, and show the Lands Commission that the money is available. Not go and take the land and we'll go and look for money. No. Not go and take the land and we'll go and look for money. Also, the 3 modes by which the state can get land are clearly spelled out. That the state can get land either through an acquisition or purchase or gift. And where the state gets a gift, certain procedures will have to be followed. Because you see, we realize that in some cases, community people will come and say, we want a fire service station in our village. We want a secondary school. Then the chief comes to say, I've donated 500 acres of land to the state. So the school is positioned on the land. Then down the road, the people will now apply to the state for compensation. And they are on a looter. Every day, they are going there to try to harass government occupiers on the land. And the reason is compensation hasn't been paid. But the chief said he has gifted, he has donated, because it is possible that if not because of the free land, that project wasn't attractive for that location. But because the chief said free land, the state has come. And now the state has come, they say, hey, you have come, pay compensation. So this act has clearly set out that the state can take land by acquisitions or by purchase, going to the market, or by a donation, a gift. And specific rules have been set out where the state gets land by way of a gift. Now, I said, if you go to chapter 8, it talks about vesting, starting from section 268. Vesting is the brother of compulsory acquisition. They are cousins, maybe. Because the acquisition, basic acquisition, is where the state exercises the power of eminent domain under Article 20 and compulsorily take the land. Vesting is where the state has not exercised the power of compulsory acquisition, but the state has taken away the management powers of the landowners. So in the past, vesting was done under the Administration of Lands Act, Section 7. But compulsory acquisitions were done under the State Lands Act, which in effect meant that the processes and the effects are not the same. Then somewhere 2008, thereabouts, I was still working at the Ministry of Lands. Those of you who remember the case called the Osumanche layout case, the Nino Teomabo and 3 others against the Attorney General and Lands Commission, the Osumanche layout case. In that case, the judge who read the unanimous position of the Supreme Court, Justice Teria Modibo Okran, of blessed memory, speaking for the Supreme Court, said, with the coming into force of this Constitution of 92, there can be no new vesting of land in a precedent. But the lands which have already been vested will remain vested until political decisions are made to divest them. But there can be no new vestings. So if you look at 268, it's clear. 1, on the coming into force of the 1992 Constitution, it is unlawful to vest, tool, or skin land in the state. So this is a codification of the judgment in the Osumanche layout case, that with the coming into force of the Constitution, there can be no new vesting. Now, in the drafts, we added clan and other lands. So even though the original position was about only stool lands, we realized that one of the things that had been abused by politicians was the use of acquisitions and vestings. Because all the time that these politicians vested lands, they never solved the problems which necessitated the vestings. So if you go to Nkoko, the lands in Nkoko were vested because Atibie and Obomi were fighting over ownership. These lands were vested, nobody went there to solve the problem. The lands within 1 mile radius of the Winneba roundabout, vested because Ewutus, Efutus, Gomues were all fighting. When the lands were vested, nobody did anything. Everybody went to sleep. The lands in Winneba town, vested. So we realized that take away the power of vesting from the politicians. So if you look at 2682, it says, after the coming into force of this act, it shall be unlawful to vest clan or family land in the state. So we said clan lands as well as family lands can also not be vested. So in other words, in this country, as we are standing here today, under 1036, there can be no vesting of land. And then in section 270 and 269, particularly 269 before I go to 270, the Supreme Court advised, I was part of the legal representation in the Osumanchi layout case. The Supreme Court advised that we should not take or exclude the customary owners from vesting, from management of vested lands. They should be part of the management of vested lands. So 269 says there should be management committees on which there will be representation of the landowners before the vesting. And 270 says the state, through the Lands Commission, within 6 months of the passage of this bill, of the coming into force of this act, they should set up a committee to advise government on what to do with the vested lands. And I don't know about it because I'm not directly involved in the system. So now let's go to the specifics about surveyors for a few minutes, and then we can wrap up. I mentioned already the Survey Act, Act number 127. Interestingly, the Survey Act was not repealed by Act 1036, but Section 11 of the Survey Act has been repealed. So the Survey Act of 1962, Act 127, if you go to Section 282 of Act 1036, it specifically says that Section 11 of the Survey Act is repealed. Now, Section 11 of the Survey Act has to do with the power of the chief surveyor to direct the surveys, to instruct, authorize. Now, if you go to 1036, there is Section 23 and 24, which is giving that power to the commission, to the Lands Commission. And I think that's the reason Section 11 was taken out. So that you wouldn't have two conflicting authorities giving authorization for surveys. So Section 11 of the Survey Act is gone. But the rest of the Survey Act is in place. Now, you will notice that there are provisions of the Survey Act which have parallel provisions in Act 1036. And the question that one has to ask is, in that regard, which provision will prevail? And the rule of interpretation is simple, that when there is a conflict between an earlier legislation and a more recent legislation which are of the same rank, because the Survey Act is a primary legislation. The Land Act is also a primary legislation. So in the event there is a conflict, then the provision of the Land Act, which is recent, will have to prevail over the provision of the Survey Act, which is older than me. So that's the Survey Act. And remember also that apart from the Survey Act, you still have your LI 1444, which is the Survey Supervision of Plans Regulation 1988. Now, that is also there in place for the surveyor. And then there are specific provisions in 1036 which the surveyor must apprise himself of. And I'm trying to see if I can share some of them for the period, the time that we still have. The time that we still have, what we can share from 1036. From 1036, I would refer you to Section 23, which has to do with the power to authorize surveys. Section 24 requires that occupiers of the land, where they make a demand for your authorization, you have to produce an authorization to them. So you go to the land, make sure that you have a copy of your authorization from the appropriate authority. Because where the occupier raises a question, you must show what we call in the law quo warranto. What is your warrant? And you know where this is coming from? It is coming from section 23 and 24 of Act 1036. Section 23 says, subject to the provisions of the Constitution, the Lands Commission had the power to authorize surveys. Subject, and that provision is Article 18. Article 18 of the Constitution is the provision that guarantees private property rights. Remember, you are going to survey someone's land. That land is private property, and that property is supposed to be protected against invasions. So you must be duly authorized to go and do it. And where you are asked about your warrant, you have to show your warrant. So not just take your instruments and hit the ground running. Demand a warrant from the person who has authorized the conduct of the survey. In this case, the commission, which is the Lands Commission. Because otherwise, somebody says, there is an offense for obstructing surveys. If the person reasonably demands to see your warrant and you refuse to show the warrant, and as a result, he decides not to allow you to the land to do the survey, you may have a challenge mounting a criminal action against the person for obstruction of survey. Because, even under the law of arrest, the Constitution says a person who is being arrested must be told immediately, in a language they understand, the reason for their arrest and their right to counsel of their choice. If you fail to do this, the arrest is unlawful. You see, so the idea of the warrant is something that you have to take seriously into account. 25 has to deal with compensation for destruction caused during survey. It's still part of the old law. It's not new. 26 has to do with boundary marks. And 27 has to do with destruction of boundary marks. Now, if you look at the penalty for destruction of boundary marks under Act 127 versus the penalty for destruction of boundary marks under 1036, if I was the prosecutor, I will not charge any person for destroying boundary marks under Act 125. I would rather charge under 1036 because the penalty, which is set out in 28 for obstruction of survey and 27 for boundary marks, are hefty. They are stiff. So I would rather charge somebody there. Now, when it comes to titling, this is one area where Act 1036 gives a lot of responsibility to the survey profession. From Section 84 of the Act, everything is about surveying. In fact, titling is really about surveying. By the time the surveys are done, the rest of the people, what they have to do is minimal. So please flag Section 84 on demarcation, 85 on the preparation of the registry map, 86, 87, 88, 90, 91, 92, 93, 94, and then 109, 110, and 116. So from Section 84 through 94, everything there set out under land title is the functions of surveyors. Everything there. So 109, 110, and 116. The same applies to deeds registration. All the most important ingredients for carrying out deeds registration is coming from the surveyors. So I will take you to Section 207, 208, and then Section 241, 243, 246, all are talking about the role of the surveyors. In conclusion, one would say that if you look at Act 1036, particularly in land management and land administration, all the provisions that have to do with land management and land registration and land administration, the role of the surveyors is central. The capacity of the surveyors to deliver would be the benchmark for delivering the rest of the activities. If the surveyors are not able to deliver the maps, those other people are waiting in vain. So I think it is about time for the profession to take this act and within the framework of the act and LI 1444 and what is still relevant of Act 127, the survey entities can make a very substantial contribution to land administration and land management in this country. Having said this, I would thank you for giving me this opportunity. I needed 10 hours. But we take it that this is part of education. It doesn't end in a day. So wherever we meet, we'll continue the conversation. I thank you for the audience.
Thank you very much, Lawyer John. I think we can do it better than what we just did. We can do it better for him. Thank you once again. In fact, I think I need to enroll for some course in the law because it's not easy. All right, so we want to make time for questioning so that he talked about a lot of things, and then from the Acts, I think some of us, our dictionary or our Bible used to be the Act 127, and then the LI 1444, and then the is it 567? What? No, 767. Yes. Now we have another Bible, and we need to hold that dear. And the sessions to consider: 23, 24, 25. 26, 27, 84, all the way down to 110, 207, 208. And we were told that without us, the others will wait in vain. That means we have the power to deliver and to make the nation move forward. Lawyer, once again, we say we thank you and God bless you so much for making time to deliver. Now, it's question time. If there are any questions in the house, I think we can start taking the questions from here.
Thank you, Mr. Speaker, MC. Lawyer, my question is, my name is Kingsley Boateng. I was hoping to have heard about obstruction of survey more detail, because as survey practitioners, one of the major encounters that we do have is obstruction and the penalties and associated problems. That's my first question. My second question goes to the leases that you mentioned, that the expiration of the current system of leasing has been structured that it continues automatic. But I don't know whether it was stipulated the extent of the renewal. Does it mean the landowner can come with a renewal such that you may not be able to, or your children may not be able to, or your grandchildren may not be able to? But I presume maybe the law has been framed in a way that you expatiate on that. And then coming back to that's my last question. You mentioned that we as surveyors need a warrant to go to the field. As it is, we've been licensed by the commission. And so when you talk about warrants, Does it mean when we apply to the Lands Commission for a regional number, that can serve as our warrant, or we need a special warrant, or we need to show just our credentials for us to do whatever we have to do? Thank you.
Okay, so first one, obstruction. Obstruction is 28. The penalty for obstruction is 28. Okay. So first for the obstruction. Hello. So let's look at obstruction. A person who willfully obstructs, 28. A person who willfully obstructs or resists A, an official surveyor or licensed surveyor in the execution of duty under this chapter, or a workman or other person acting under the direction of that surveyor, commits an offense and is liable on a summary conviction to a fine of not less than 1,000 penalty units and not more than 10,000 penalty units, or to an imprisonment not less than 1 year and not more than 10 years, or both. So a penalty unit is 12 cedis. So if you are fined 1,000 penalty units, it's 12 multiplied by 1,000. That's the minimum. Or 10,000 penalty units, or 1 year imprisonment, or not more than 10 years imprisonment. So it's a serious situation for the obstruction. Now, look at what the law says on the warrant. Power of entry and demarcation, or survey, 24. The Lands Commission may, in writing, authorize an official, surveyor or licensed surveyor to enter upon the land to carry out demarcation or survey work specified in the authorization. Interestingly, the language here is not shall. It says the Lands Commission may. But if you read up to the end, it talks about a person authorized shall, on demand by the occupier of land upon which that person enters, produce to the occupier a copy of the authority. You see, so that's the reason why I am trying to interpret this as if it is a shall, a mandatory shall, because the may means permissive and the shall is mandatory. But we go on to the next clause, which is telling you, if you go to the land and the occupier makes a demand to see your warrant, you should produce the warrant. So if you don't have the warrant, and you know, these days, people's eyes are opening. You know, people's eyes are opening. So the thing about the warrant, that's where, and it says a person authorized under subsection 1 shall not enter into a building or upon an enclosed court or garden attached to a building unless that person has first sought and obtained the consent of the occupier of the building or enclosed court or garden. Failing the consent, has been given the occupier 14 days notice in writing of intention to enter, and so on and so forth. So that's why 23 starts with the Lands Commission may, subject to clause 2 of Article 18 and any other. So the subject to clause 2 is the protection of private property rights. Is the private property rights protection, so that you can't just come and be walking through someone's land and saying you are surveying. You are going to have issues. The leases, very interesting question that you asked. So listen to what section 59 says. Where a lease in respect of bare land is granted by a person who holds the allodial or usufruct and the lessee is an indigene of the area, the lease is subject to automatic renewal where the lessee has developed for residential purposes, or a farm or perennial crops on the land, a commercial or industrial property on the land, for the same duration as the original lease when the lease expires. So, an indigene, it is for the same duration as the original lease. So, the thing about the landlord changing their mind will not happen. But this is for indigenes. The next clause, which is not too different, has to do with where the lease is granted to a person who is not an indigene. That one, the law says there shall be an implied term that it shall be renewed. So the formulation is slightly different. But what you are talking about, if you go to 12, it says a lease of bare public land, which is a government lease, granted by the Republic to a citizen of Ghana, is subject to automatic renewal on terms agreed by the parties. So if a Ghanaian gets a government lease, that will also be automatically renewed. A non-Ghanaian's lease does not enjoy the same privilege. So that's the essence of this change that we've been talking about.
Thank you. Okay.
Thank you very much. My first question to the speaker is one of the issues of concern to licensed surveyors and the general membership of surveyors is about fronting of surveyors. Fronting of surveyors. Is the act, does it have any section that talks about sanctions of surveyors who front for other works? My second question is about what you just talked about. If you look at the various interests, you talk about allodial title, you talk about customary freehold, usufructory rights, customary tenancies, and so on and so forth. And then if you go to the registration side, most of all these rights are registrable. Now, again, why is the need for an indigene to register the land as a leasehold if there is a possibility of registering my usufructory rights? Because from the question that Surveyor Kingsley asked, for the indigene, and then what the lawyer tried to explain, an indigene can have extensible kind of leasehold, which is slightly different from maybe a stranger. But as an indigene of a place, if my usufructory right can be registered, do I still need to have a leasehold? That's fine. Thank you.
Interesting things about 1036, it avoided a regulation of the practice of survey because it was very controversial. Nobody wanted to go close to it. So if you go through all of the provisions of 1036, what you are talking about in terms of regulation and fronting, you will not find it. What was captured is the work of the surveyor. But regulation in terms of practice, you only have to go to the scattered provisions of 127. I believe the plan was for survey to create something like, you must have a robust system like the General Legal Council. Yes. We were working on the Survey Council bill many years back. Was it passed? Exactly. Exactly. We worked on the Survey Council bill. It wasn't passed. So you need a professional body that is statutorily authorized to regulate survey practice. You couldn't take that into account in the Land Act. It came up, but nobody wanted to talk about it because some of us were of the view that it was not appropriate in that location. That if you need a regulatory body, push the Survey Council Act and get your regulator for the practice of surveying. So all your issues could be set out. So there is the Legal Profession Act, and then there is the Professional Practice Regulations, which govern lawyers. And they are not the same. And there is the Bar Association, which you can decide not to join. You know, so you have to up your game in that regard. We couldn't have, by default, filled in the gap in terms of professional regulation. It was not the appropriate location. The forum was not convenient. Because you'll be surprised that for most of these legislations, you know, surveyors generally are quiet people. You know, you could sit in a meeting, all this drafting. How many surveyors were part of the drafting committee? There was, what is his name? Marcus. You know, so the rest, you know, overshadowed the surveyors. And so the next one was so the license and the, what was your other question? The usufruct. You remember what I said? From S. particular, indigenes were even denied registration. But now, because of Section 9(3), indigenes would register their usufruct. You need to sensitize the landowners because the chiefs already have absorbed the S. particular position, which said, which came out of the Lands Commission's commandment that they will not register the freehold. So once the Lands Commission understands that going forward, for indigenes, you should register a freehold. But look, the challenge here is, how do you determine an indigene? An indigene. What kind of certification is required to prove your status? Is it that the chief will issue a certificate that this grant is to an indigene? I mean, so yes, the bill has been passed into law, but operationalizing it, because look, the idea of restricting freeholds to non-indigenes was based on the principle of intergenerational equity, that the land should not leave the land-owning group permanently, and that some people should make some money from leasehold rents, not freeholds which attract no monies into the future. You see, so you need to put in place a system, and this has to be done by the Lands Commission, that determining an indigene. Otherwise, everybody will become an indigene. So,
thank you. We now go online. From online, we have a please in the Upper East region, land ownership is individually general. It's individual generally, but the leases are always done between the Tindana or chief and the one buying the land, leaving the real owners to take the places of witnesses or farm owner. So may I know who will be the rightful owner when the lease is to be renewed?
Okay. He's talking from the Upper East.
Yes, please.
Okay. I did a case in the Supreme Court around 2017. Tindana Akubayela. This case was between the Tindana of Tindonsobligo and a family called the Aure family in Tindonsobligo. And the question was whether the allodial title was held by a Tindana or by a family. The Tindanas lost in the High Court in Tamale. They lost in the Court of Appeal in Tamale, and I took the appeal up. They brought the appeal to me after they lost twice. I went to the Supreme Court, Tuguba JSC presiding. I won unanimous. The Supreme Court said that Tindanes, who by custom are the descendants of the first settlers, hold the alludia title. But families would hold a title below the Tindanes. So this person who says he's a member of a family, from the Supreme Court judgment, where the land has already been occupied by a family and developed or cultivated, Tindanes don't allocate. The Tindanes allocate land which is unencumbered. So it's been clarified. He has to understand that this position has been clarified by the Supreme Court. And even in this case I'm talking about, the Supreme Court agreed that some revenue sharing between the Tindana and the families, which they have agreed upon at their level, should be enforced by the Supreme Court. So the individual will not lose out as such, but we need some more education to explain some of these judgments.
Thank you. Another question says, please, I want to find out whether the Land Title Registration Law, PNDC Law 152, is still operational with the enactment of the Land Act 1036.
It has been repealed in section 282. So PNDC Law 152 has been repealed in its entirety. It's been completely repealed.
Another question from online. Please, I want to be very clear. Does it mean registration by conveyance is no more, or what can merit a purchaser to register by conveyance? Thank you.
Now, a conveyance is still a conveyance, and it's defined in 281. You go to the definition section in 281. Conveyance. A conveyance includes a document in writing by which an interest in land is transferred, an oral grant under customary law that is duly recorded in accordance with this act, a lease, a disclaimer, a release, or any other assurance of property or an interest in property by an instrument, which is expansive, and it covers whatever you are talking about. So it shouldn't be a problem.
The last question from online, then I'll come in-house. This one says, thanks. The new act, according to the legal expert, shows that Section 11 of Act 127, which gives power to authorize and direct surveys, had now been repealed, and authority given to the Lands Commission. Why then do we continue to have a position in SMD termed acting or confirmed director of surveys? What is he directing? A surveyor requires an authorized letter from the Lands Commission. Is it a one-time authority note or a day-to-day authority note for every job?
Yes, I think, you remember I said the law, the act is in place now, but operationalizing it is another, so somebody at the Lands Commission working together with the survey group should agree on how it will look like, the nature, because the lawmaker just says, provide an authorization. And the lawmaker does not provide for the form of the authorization, unless maybe if you go back to the schedules, because from page 152 of the Act all the way to 200 and so 152 to 211. are all forms. So the first form is record of customary transaction, how a customary transaction will be recorded. So you can check, so precedent of a conveyance of a gift. There is extensive forms have been added. If you look at the forms section and your situation is not covered, then something has to be improvised. But I mean, like I said, this piece of legislation is pretty well thought through. It's a lot of work went in and a lot of years. So probably better than most laws that have been passed in this country.
So follow up, yes.
You see, remember this thing about director of survey. The fight also was not just about survey. Forestry Commission. There was a position called the Chief Conservator of Forest, which in the past was a very powerful position. White man who was carried on people's back. And that position now is the Chief Executive. Then, in the Minerals Commission, there was a position called Chief Inspector of Mines, which also now became the Director of the Inspectorate Division. Then there was a position of Director of Surveys, which in 127 is Chief Surveyor, which in Section 19, because the SMD became a division of the Lands Commission. Look, if you go back to the repeals, give me the. If you go back to the acts, the photocopies. If you go back to section 45 or so of 767, it talks about, you bring me all, it talks about some transplant of, so this is 767. It talks about some transplant of certain names and certain positions. Apart from the dissolution of specific bodies, talks about, so 45, consequential amendments. On the coming into force of this act, unless the context otherwise requires a reference in the Land Registry Act, the Survey Act, the Land Title Registration Act, and any other legislation in force to Land Registry, to Land Title Registry, to Chief Registrar of Lands, Registrar of Lands, Land Registrar, Director of Survey, Survey Department, Survey Division, Official Surveyor, all shall be references to the commission. So the reference to Chief Surveyor and so on shall all, since 2008 under 767, shall be references to the commission. So if we are still describing somebody as Director of Survey, it's like you have changed your name and you are using it.
Thank you for the opportunity. If I could recall, when if I could recall, when a group of people took the if I could recall, when a group of people took the commission to the Supreme Court, I think there were some reliefs that were given. We were told that the Director of Survey will still perform its mandate as enshrined. However, we will still be part of the Lands Commission. If I could recall, I cannot really recollect what the release was. That's what I want to know. Then, so our plans we shouldn't be touching it.
I have I run a law reporting service. I run a law reporting service called the Ghana Monthly Judgments. I'm the editor-in-chief. So all the law cases, and in the volume, this is GMJ, January 1st, 2018, part 116, 2018, which is 116 GMJ. at 388. This is now at page number 218. There is a report which I did here. Lansing Surveyors Association of Ghana, Kwame Tinedu Senior versus the Attorney General and Minister of Lands and Natural Resources, Supreme Court. Atuguba, Akufo, Ansan, Adinyira, Boni, Badegbe, and Benin. And this is the full judgment. I can donate this to the association.
Thank you.
Yes. So that you can make copies for yourself and try to understand what happened. Interestingly, when that case went to court, the Attorney General then called me and said, you were the main actor in this bill. So we are in court. So we sat in the AG department and with Mrs. Afiri and Son, we prepared the submission from the Attorney General, which went to the Supreme Court. So, just read this and see what happened. That's why I was saying, if I were surveyor, if I were a surveyor, this is your best time. Because with the role, the centrality of your role going forward, and all this digitization of things, the surveyors are virtually indispensable in land administration and land management. But because the surveyors are not mostly in town, they are quiet as well. I remember on one occasion when we were talking about, we were worried that we didn't have too many surveyors contributing to the drafting. And I raised it all the time. We were told, oh, the surveyors, they are busy making money in the bush. So they are not interested. And the others were always coming and they ended up. But like I said, your role in this thing is central. Even if the surveyors were not at the table, you could still not run the system without them. So make yourselves relevant.
Thank you. Can we assume the ID card of licensed surveyors to be part of the authorization when we get to the land or when we are going to survey a parcel of land?
I guess you would have issues.
Okay.
If you are relying on your ID card, you will have issues.
Okay.
Because the authorization is supposed to be in writing by the Lands Commission. And you have to be careful, particularly because of the rights issues that might be implicated. I think this one will be the last.
Yeah, thank you. Thank you very much. On the question of Director of Service, I think since Survey Department is part of Lands Commission, I don't think the ES, who is a valuer, can write to or give you permission to go to a land. That means contact the Director of Service for that. Now, my question is, now the 1036 is in force. Those who are squatting on government land, can they be immediately be dislodged? And then I'm looking at this vis-a-vis an earlier instruction which said that if government acquires the land for a specific purpose and it does not use it for it, the landowners should be giving back the land. Thank you.
Ms. Akwa, question first. That what you said is one of the issues which have been seriously misinterpreted in this country. It is coming from Article 20, clauses 5 and 6 of the Constitution, the point you have raised about getting your land back. Under our law, there is no automatic right of re-entry after an acquisition. because our law is clear that an acquisition extinguishes all the titles prior to the acquisition. So you cannot re-enter. You have no land. And before at 1036, it didn't matter whether compensation has not been paid. Once the instrument of acquisition is published, the acquisition is effective, your entitlement is to sue the Republic for your compensation. Now, Article 25 and 6 say that when land is acquired for a public purpose, the land should be used for the stated public purpose or in the public interest. And where that purpose has failed, the state should give an option. This is what we call the right of preemption. An option to the pre-acquisition owners to buy back their land, either by refunding the whole or part of the compensation if it has been paid. So it becomes a political decision to allow you get back your land, not an entitlement. You know, this is the outcomes of, there's a case called Amontia and Ghana Telecom. The Bubuyashi. Yes, it went to the Court of Appeal. The guys, the applicants who are the landowners, they lost in the High Court. They went to the Court of Appeal. They lost unanimously, and they didn't go to the Supreme Court. But the La Wireless case, the Ghana had 50, close to free zones. Yes, the La Manche, Ni Kobitetechuru sued the Attorney General and Lands Commission that the lands were taken for wireless stations. And if the state doesn't need them anymore for wireless, the Supreme Court said, look, Article 20, clauses 5 and 6 will not apply to acquisitions which were done before January 7, 1993. So all the acquisitions which were done before the Constitution was effective, 25 and 6 will not apply. So that side is also closed. So there's no right of saying, I want my land back. It doesn't exist under our law, except that, you know, sometimes politicians, they will not ask, and then they will be making pronouncements. That's the problem. But otherwise, you are fortified by the Constitution. If the land is acquired after the coming into force of the Constitution, then otherwise, you see, so that's where we are.
Okay, lawyer, my question is about the formation of National Lands Commission Board and the Regional Lands Commission Board. In your speech, you said the map, a good quality map, enhances a good land administration system. My question will be on the Director of Survey. Why the Director of Survey was left out, both the Constitution and the 767, as a member of the Board of the Lands Commission?
And then another question. Another question. Someone wants to know, although the Act 1036 section 50 subsection 12 stipulates that the renewal of leases is automatic per terms agreed by parties, what happens if the lessor demands that renewal of lease will be done under current value of land? I'm asking this based on recent development at Adabraka. Because of time, I think we want to put 2 or 3 more questions and then
Thank you. Please, I want to find out something. The understanding I got from your this thing is that if you actually want a freehold, then it's better you go to your hometown. I don't know if that is right, but when, yes. So when these laws were, you promulgated this law, I mean, when you worked on these laws, did you envisage that some of these provisions will go into retrospect? Because if I had an agreement to have a freehold from a town that I don't belong, and I have that document, Now I try to register it and I'm told there's a new law which doesn't allow me to do that registration. So I don't know whether there's anywhere in the provisions that states where this thing starts and where it's supposed to end. My last issue is, no, not just a short one. You mentioned that it is only lawyers who can draft conveyance. That's understood. Surveyors are the ones that are supposed to give you the schedule, right? So I believe that in future, surveyors are also going to charge by a percentage for the schedule. No, we prepare the draft, we prepare the indenture, the side plan, but we don't charge the lawyers. Now we are going to give the lawyers a bill.
And then if, for instance, I work for a family and they are not able to pay me the full amount, and then they want to pay part with land, how do I register that? Do I register it as freehold or? Yeah, thank you.
You talked about being paid in land. If it is valuable consideration, that should amount to like a conveyance, a purchase, because professional services are quantifiable and capable of being priced. So you wouldn't have too many problems. The real challenge here is the lease. When the drafter says it shall be renewed in accordance with the old terms, the drafter, and I'll tell you the truth, the drafter's main concern was the auto renewal. And it is possible that some terms would have to be reopened. If the lease was for 1 cedi 100 years ago, will it still be 1 cedi? Legislation like this, you need some regulations to give force and effect. And that's why I was saying this is where the Lands Commission has to really sit. Because the law talks about Lands Commission having the power to make regulations, for the implementation of the act. If they are not able to rise up, so 280, the minister may, on the advice of the Lands Commission by LI, make regulations, and it's an extensive list of things the Lands Commission has to write regulations to cover. And if the regulations are not written and promulgated, there will be some gaps in the implementation of this regime. And the way we do things in this country, you pass the legislation, nobody will prepare any regulation. You leave it to the administration, the public officials with their own fiat. They will create their own systems, which will come back to haunt all of us. So, it's not that easy. If they don't promulgate regulations, implementation challenges will be enormous. So I think we have come to the end.
No, lawyer, I'm supposed to ask the last question. Lawyer, I'm very grateful for all the things you have said. Having worked with you in Lap 1 and having known your immense contribution and the knowledge, in-depth knowledge that you acquired in Lap 1 as far as surveying is concerned, and having mentioned that survey is central to land administration and land tenure system, and then having said that in the drafting of 1036, you realize that, or the drafters realize, surveyors are quiet people. Would you say that 1036 has been fair to surveyors?
I think 1036 has been fair to surveyors, even if they were not at the table. Because if you look at what has been said about valuation in 1036, you would want to say that the valuers should pack their things and go. surveying, like I said, is land management. You can't have land management and land administration without it. I think surveyors, there was a perception, to be honest, when some of us came to the Ministry of Lands 2003, there was a perception that the surveyors were not very knowledgeable. That was the perception. It was the perception until when we passed 767 and we were looking at who goes to become regional lands officers. And we sought and obtained the CVs of the people in the land sector, and we were shocked. We were very shocked that the surveyors were very knowledgeable. Why they were timid, nobody knew. Why they were timid, that one I can't tell. Because there were surveyors, I won't mention names. We had called to the ministry and proposed as regional lands officers, they said no. They said no. Important, senior surveyors wanted to put some in serious regions. They said no. They said no. So it's not the fairness of the lawmaker. It's the institution itself not being fair to itself.
Lawyer, I want to be Oliver. I know you are tired, but let's just attempt to answer this last question from online. Historically, land is acquired by first settlements on vacant land by grant from first settlers, sale, and conquest. References the Upper East Region case, where a family acquired the land by grant from the Tindana first settlers. Should the Tindana still claim a Alodia title over the said land, for which reason they are entitled to compensation? Thank you.
Okay. You see, what he has to understand is this. There are two levels of compensation. There is reversionary interest compensation and compensation for the active rights on the land. Remember, even where the Tindana holds the Alodia title and the family holds the usufruct, there is still what we call the residual proprietary interest or reversion. In the event that the usufruct fails, the Tindana's Alodia title will trigger. So you can't say that where the Tindana has made a grant and the family has also allocated to an individual, the Tindana has virtually evaporated from the scene. No, the Tindana's rights are in abeyance. It's like it goes into a dormancy. But there is that remote possibility of a reversion. So when you are computing the compensation for an acquisition, you have to look at the reversionary interest of the Tindana. It may not be as much as the usufruct, but you have to take that into account.
Thank you very much. For both our online viewers and those in-house, I think we need to give another applause to Lawyer Jan for a great work done. We thank you very much, and I believe that this is not the end of it. More questions will follow. We'll try to contact you both online. Yeah. I now give the mic to the chairperson to give us his closing remarks.
Thank you very much, MC. I am so happy that we have come to the end of this program successfully. But I just want to thank Lawyer Kwame Jan for actually opening our eyes to the contents of Act 1036. There is only one thing that I want us to be the takeaway. We all heard from Lawyer Kwame Jan that surveyors are at the center of Act 1036. If land management and land administration will be successful in Ghana, it depends on surveyors. That should be our takeaway. Thank you very much. And I hope anytime we call on you, you'll be available to actually hear. Thank you.
Thank you very much, Chairman. We now call on our brother Alex Aite to give us the vote of thanks.
All too soon, we have come to the end of the second session. We started in the name of God, so we want to say thank you to God Almighty for bringing us thus far. We've had a successful session. We received a lecture from lawyer Kwame Jan, but this session couldn't have been possible without our chairman, so I want to say a big thank you to our chairman, survey president. I also want to thank, in his absence, lawyer Kwame Jan for the key revelations he made in the Act 1036, especially the specifics on land surveying. We are grateful, and I believe we've all been equipped of these key provisions in the Act, and will be guided by these in our line of work. I also want to thank the planning committee, the chair and members for a great work today. We've had a smooth delivery so far for those here and also those online. I want to thank the IT units for their efforts, Surveyor Nwagbe and also his team for a good work done, and also to the general members, those online and those here. Thank you very much for being here. We hope to see you tomorrow when we welcome the YSN also. So we end this in the name of God Almighty, in the name of the Father, in the name of the Son, and in the name of the Holy Spirit. Thank you all.
Thank you very much for that powerful vote of thanks. I was thinking you're going to say that to everybody, vote of thanks. Yeah, we will take our closing prayer and then we call it a day. Let's pray. Our Lord and our Master,
institution of excellence that promotes world development of all levels. If every heart let us work to sustain the image of the sovereign practice, to be recognized as a professional institution of excellence that promotes world development of all levels. Integrity, environmental sustainability, excellence, leadership, respect for profession. Let us come together to the praise of the service with integrity, integrity, environmental sustainability, excellence, leadership, respect for profession. Let us come together to the praise of the service with integrity,
let's pray. Daddy Lord, we thank you so much for how far you brought us. Thank you for a successful program. We pray, committing our departure here into your care, that you take us to our various homes, and the things we were taught, help us to stand by them and to use them for our profession. We thank you and we bless you in Jesus' name. Amen. Thank you once again, those online, for making time. God richly bless you. And we trust and hope that you will make good use of the lessons learned today. Thank you and bye-bye.